Should be live.
Okay, I have to do one introduction just a second. Good morning, everybody, and welcome to our January monthly training. My name is Tiffany Ziegler, and I'm the Training and Compliance Specialist at the Medina County Board of Developmental Disabilities. Joining me today is our presenters, John and Igor from Community Legal Aid, who are here to speak to you on housing and rental information. Before we get started, I want you to know that you are able to ask questions throughout the presentation in the comment box that may be found either to the right of your presentation screen or maybe below. Today's training is being recorded and will be able to be viewed at a later date on our Medina County Board of Developmental Disability YouTube channel. So without further delay, I'm going to turn today's presentation over to Igor and John.
Thank you, Tiffany, and thank you for having us today. My name is Igor Petrovich. I'm an attorney in the Housing and Consumer Division with Community Legal Aid, and I'm joined today by John Pettit, who's the managing attorney at Community Legal Aid. So what is legal aid? Legal aid is us, and what we do is we provide legal services in civil cases free of charge to low-income residents of 8 counties in Northeast Ohio, going from Medina to Summit all the way over to Trumbull and Mahoning counties as far south as Stark and Wayne as well. Those are the ones in this immediate area. We provide assistance in all sorts of legal problems, including the following: consumer, housing, family, and then public benefits and unemployment. We also help with certain tax disputes as well as bankruptcies. To be eligible for our services, you generally have to be 200% of the poverty level or below, with some exceptions, or 125%, usually without any exceptions. We also have dedicated funding for certain groups, such as those who are over 60, veterans, those who are disabled. So if you think that you may need some legal assistance, you should apply and not assume that you're not eligible. And as far as housing cases, which is what John and I do, we do evictions, which is formerly known as forcible entry and detainer, landlord-tenant problems, including conditions cases, security deposits, utility terminations, lockout, health code violations, for example, if you have mold, and then any other really housing issues that you may have, including foreclosures, or sometimes even mobile home issues. This is our contact info here. It has our hotline phone number, which you can contact us to apply. You can also apply online at communitylegalaid.org. If you go on our website, communitylegalaid.org/events, you can find a list of all of the many events that we have that are open to the public for the most part, including on Wednesdays at 5 p.m. when we have Ask a Lawyer, where one of our attorneys on a rotating basis will discuss different topics. For example, this week we discussed taxes and the stimulus payments. In previous weeks, we've discussed protective orders for victims of domestic violence, housing issues, unemployment. So if you go on our website, you'll be able to find that. Also, every Tuesday at 4 p.m., John and I and other housing attorneys are there to do a Q&A for just housing questions, and that you can find information about that once again at communitylegalaid.org/events or on our Facebook page. So what are some of the common I can't be evicted myths that we hear? I can't be evicted because I'm pregnant, because there is a holiday, because I have children, I'm in the hospital. People think it takes 30 days after judgment for set out. Usually it's within 10 days. Sometimes it can even be the next day. Right now I'm looking outside and it's snowing. People think you can't be evicted during the winter. You can. I don't have anywhere else to go. That's not a defense. Rent was 1 day late. Sometimes that is a defense. If your landlord has a habit of accepting your rent late and then all of a sudden they say no, that can be a defense. no job or lost a job, usually not a defense. And so if you are being evicted and you have questions, you should definitely contact us and not assume that you can be evicted or assume that one of these things applies. Talk to an attorney who can tell you what the law is. So for example, with that no job or lost a job, usually that's not a defense. However, we are currently experiencing a global pandemic for the past year. And if you are using your best efforts to obtain financial assistance, you made less than $99,000 per adult individual, or 100, whatever that is, doubled, 198,000, or received a stimulus check, you're unable to pay your rent because you've lost either hours or wages, or you have extraordinary medical expenses. If you're trying your best to work with your landlord, if being evicted would make you homeless or have to share your housing with others, then you're likely eligible for the eviction moratorium. What is the eviction moratorium? The eviction moratorium means that you can't be evicted for non-payment of rent. And currently, that moratorium has been extended to the end of March. What it does not mean is that you can't be evicted for anything. If you violate rules, for example, criminal conduct or something like that, then you still can be evicted. This protects you if the reason you're being evicted is for non-payment of rent, and those factors apply. So if you have lost your job or income or are unable to work because of the current pandemic, you can go on the website, the CDC website that I've linked down there, and you can give that form to your landlord. If you have a pending eviction case in front of the court right now, you want to give it to your landlord, you want to give it to that court, and you definitely want to go to court and say why this applies to you, because it can give you time to actually get some community resources, apply for financial assistance, because there are numerous programs out there right now designed for people who have been affected by the current pandemic. And so John is going to talk to us a little bit about the different types of rental housing that exist out there. John?
Yeah, thanks, Igor, and good morning. And we're really just kind of giving an overview here of your rights as a tenant. And as Igor mentioned, often people kind of assume that they won't be evicted for various reasons, and they go into court, and that's not necessarily the case. We don't tell you that to scare you, but we tell you that so that you are prepared, and hopefully you can reach out to us. Igor also mentioned our website too, and you can find a lot of information on our website. Yeah, he's going back there, the communitylegalaid.org. We have actually a toolkit for renters on there, and it really is. There's a booklet on there, a virtual booklet that you can look at to see your rights and those types of things. So I encourage people to look into that. But so yeah, so going back to the different types of rental housing, and we're going to touch on these just briefly. So some people are in private landlord-tenant relationships. That's where most people rent. Sometimes subsidized, or we call it government subsidies, where the rent is reduced and paid by the government agency. It may be Section 8, may be owned by various agency, and may be subsidized by those agencies. And then there's manufactured homes, or what's commonly known as mobile homes. And so those are really the types of housing. So in private, obviously, the tenant pays all the rent. There's no government assistance. In subsidized, that typically that is from HUD, or Housing and Urban Development. Rent amounts are more affordable, and we'll talk about that. Generally, it's about 30% of your income. And then in the mobile home capacity, that is where you may live in a mobile home park, and that's defined 3 or more homes. Usually those are licensed through the health department, and those are tricky sometimes for us, especially because sometimes people own their mobile home but rent their lot, and so those are especially difficult, because you don't want to get evicted from that, because it becomes, even though they call it mobile home, they're not all that mobile. Maybe that's why they changed the name to manufactured. So it becomes very difficult move those if you get behind in your rent. So government subsidized housing, again, just touching on that, there's different types. The most easiest to navigate from a tenant perspective generally is the Section 8 Housing Choice Voucher Program, because you can get a voucher through your local housing authority, and then you can basically live anywhere that the landlord will accept that voucher and the conditions that come with it for payment. So you can move to a place where you want to go. And again, your rent generally is capped at about 30% of your income. There are some places that are entirely public housing, and so those are owned by or contracted out by a government agency, and there you are restricted to living just in one of the units in that particular building. And then there are some that are kind of a combination of both. We call those project-based rent subsidies, where they'll take Section 8, but you can't move it anywhere else. So we can kind of skip through that. That's kind of the general about the types of housing. And Igor, you want to take it away with the lease agreement?
Yeah, thanks. And so, in Ohio, if you don't have a written lease, it's going to be assumed that you are a month-to-month tenant. What does being a month-to-month tenant mean? It means that either party, the landlord or the tenant, can end the lease for any reason whatsoever with a 30-day notice. So on today is the end of January. The landlord can give you a 30-day notice saying you've got to be out by the end of February, even if you're current on rent. And so we always advise people about the advantages of a written lease agreement, because then the landlord has to, number one, he has to comply with what's in the lease, as well as the Ohio law governing the landlord and tenants, right? So here you can put in those protections about all the notices that you'd like, who's paying for what, and you'll have it formalized in writing. Is your landlord paying the utilities? Are you? If it's he said, she said, it's a lot harder to prove in court. If it's signed by both parties and it's a document saying the landlord's responsible for utilities, it's right there, and it's a lot more enforceable. Your rent amount is fixed. If you have a 1-year lease, that lease is going to stay $600 a month for those 12 months, right? The lease duration is fixed. You can have a 1-year lease, a 2-year lease, a 3-year lease. And as long as you're current on rent, the landlord cannot just say, I'm giving you a 30-day notice and kicking you out. Those are some of the advantages of the written lease. The downside of a written lease, it's hard to get out of it. If you sign a 1-year contract, you may have to be on the hook for some money if you break that lease, right? If you leave or you owe rent, the landlord may sue you for that amount. However, they have an obligation to mitigate their losses, so they can't just sit on that property if you break your lease earlier and not try to re-rent it and then come after you for 9 months of lease. Sometimes, what we see often are unlawful lease terms the landlord uses. For example, a $2,000 eviction fee is one that I saw recently that is not enforceable. So sometimes you should review some of these lease terms. I hear so often, both by landlords and tenants, well, it was in the lease. Just because it's in the lease doesn't mean that it's always enforceable. So if there's something in the lease that doesn't look right to you, reach out and see if we can review your lease. Come to one of our community events and tell us what's going on, and we may be able to give you some quick legal information about whether a term is allowed to be in that agreement or not. So what are our tips when you're signing that lease? Read it thoroughly. Try to negotiate your changes where necessary. Changes to the lease, if there's a difference and you make an oral arrangement, saying rent is due on the 1st, but I get my Social Security on the 3rd. So now we're going to make the lease due on the 8th or the 9th. Make sure it's not just verbal. Cross it out on what the lease says. You and the landlord initial it and change it to reflect what you've actually agreed to. Get your own copy of that lease with all those changes on there, because we so often see tenants who just say, I don't have a copy of the lease, only the landlord has it. And then, if you've lived there for 5, 6, 7, 8 years, you may not remember what you've agreed to. You may not remember who's responsible for the trash or whatever. And so it's important to keep a copy so that way you can protect yourself. You want to do also an inspection with the landlord, have a witness with you. You can take pictures, videos. You can just email them to yourself is what I've always done when I've rented a place. So that way, if your phone breaks, if you lose your phone, if something happens, you'll always have it on that email. So that way you can show what the conditions are when you moved in, when you moved out. So that way you can get your security deposit back. If the repairs are not completed before you signed the lease, the landlord might not complete them at all. Try to make sure those uncompleted repairs in the lease are accounted for. So that way, if the landlord agrees to fix them, make sure that they fix them. If they don't fix them, that can be your way to break the lease without punishment. As I mentioned before, sometimes we see terms in the lease that are not enforceable. Excessive late charges, landlords just changing locks and removing a tenant without going to court, keeping a tenant's personal property if they're behind on rent, or saying, I'm getting attorney fees against the tenant no matter what. So excessive late fee charges, that's for the court to decide, right? If a fee is excessive, we can enforce that. We can say it's unconscionable. Same with attorney fees. Attorney fees are determined by the court at the end of the eviction hearing. The court can say you also own attorney fees, or they say you do not owe attorney fees. It cannot be presumed that you owe them without that judgment, right? And so if the landlord's trying to say, well, you owe me $3,000 in my attorney fees because I filed the eviction, that's likely not going to be enforceable. So if you're signing a lease with roommates, there are some other issues to keep an eye on. You may want to sign a separate lease or agreement that applies to you and your rent or damages, and have that separately, because what you have when you join a lease together, it's called a joint lease. You have several joint and liability. So that means one of you may be responsible for paying the full amount, right? And so you may have an agreement with your or with your roommate saying, I'll pay half and you pay half. That's an agreement between you two. But as far as the agreement between you and the landlord, the agreement is that the full rent has to be paid. And so then the landlord is free to come after either one of you for the full amount. And they're probably going to come after the person that's paying the rent, because if the other person's not paying the rent, they probably don't have any money. And so they're going to sue you or him or her, whoever, to try and get all the money they can. If the lease doesn't specify who pays for any damage, you may have to pay for it. So make sure that you get everything in writing, especially with your roommate, because those verbal agreements, once again, are going to be difficult to prove. And now John's going to talk about rent.
Yeah, so just a little bit about some tips about your rent obligation. And some of these sound obvious, but we run into these as lawyers that represent tenants. So you have to pay the full amount, and if you can't, certainly you can pay what you can, but that can get you in an eviction situation. But if your landlord is willing to pay or to accept less, then that may be okay, or maybe a defense. But generally, you need to pay the full amount, pay it on time, and pay it as the lease prescribes. Sometimes we see that we'll ask our clients, well, how did you pay your rent? And says, well, I would just take it by cash to the landlord. And we look at the lease, and the lease says, rent is to be paid by check to a certain address, that type of thing. Does that mean the rent doesn't count? No, but it makes it very difficult to prove. And if somebody says, well, why are you paying it that way? And the lease says something else, you may have a problem there. So generally we say pay by check, money order, and not cash, because again, receipts are important. They come up sometimes. We'll see this where we will get cases where people say, my landlord said I'm $1,000 behind. I'm not. I think I'm only 100, or that I'm paid up, but they don't have receipts, and so it makes it difficult. Okay, so where to pay? Again, as I mentioned, often it's in the lease provision, but by law, if it's not in that lease itself, the landlord must collect the rent at the rental premises. So know that. Now, the landlord could change that if you make that an issue, um, and they don't want to come get it. They can change or give you a term, but they have to give you notice of that new term, and generally 30 days notice for that. So the rent receipt. So if your landlord does come and pick it up, you should get a rent receipt showing the amount paid, the date paid, what the payment is for, and have it signed by the landlord. Now, that what the payment is for is sometimes tricky, and I think we have a spot on here about that. But sometimes you're late, or you have an agreement in the lease to pay utilities and those types of things. And so it's important that you indicate on the receipt or on your check, if this is for current month's rent, if I'm paying my rent today for February, I should put down on the check February rent. Otherwise, the landlord could apply it to late fees that you may not even think you owe. So as the slide here says, if you owe 2 or more debts, each of those is a separate debt. And so if you don't specify, then the landlord can choose where it goes. All right. So if the landlord does decide how to apply your payment, as I mentioned, it might go to late fees, it might go to something else, and then you think you've paid your full amount of rent for February, but the landlord says no, that $200 of that rent was applied to late fees, and so you're late in February, or you're behind and you're subject to eviction. So I mentioned this a little bit about our government housing or subsidized housing. Generally, that is based on 30% of your adjusted income. And so that's why it's very popular program, sometimes hard to get into. There are many times waiting lists, but certainly worthwhile to look into. So there's some things here about minimum rent charge. And so some people, based on having no income, may not be required to pay any rent, but that's really part of the Section 8 program that you can check with your housing authority about that. So I'll turn it over to Igor to talk about the landlord obligations.
So a lease is a two-way street, right? You have obligations to the landlord, but the landlord also has obligations to you as a tenant. They have to comply with all the codes that materially affect your health and safety. They have to make all necessary repairs, maintain electrical, heating, supply you with running water, reasonable amounts of hot water and heat, unless you're the one that controls them and are responsible for them. They also have to maintain air conditioning and elevators if they're the ones that are supplying them. If you live in a multi-unit building, like an apartment building that's owned by the landlord, they have to keep the common areas and hallways safe and sanitary, provide you with garbage and waste receptacles if there are more than 4 units. They also have to give you notice before given access. Under Ohio law and all the case law, 24-hour notice is presumed reasonable. However, if there is an emergency, the landlord does not necessarily have to give you that 24-hour notice. What constitutes an emergency, what constitutes reasonableness, is going to be determined on a case-by-case basis. The landlord must begin an eviction if reasonable cause to believe the tenant is using or selling drugs. This is true in subsidized housing that's federally subsidized. If it's just a private landlord, it's certainly grounds for terminating your lease. So who controls a property that is rented? The answer is the tenant. The tenant has the exclusive right to live in the property. You have the right to quiet, peaceful, and enjoyment. Landlord can't just come in to say hi because they want to. They have to give you that reasonable notice. If you have that kind of relationship with your landlord and you're happy with it, then that's your choice, because you, once again, are the person who controls the property, and you have the right, exclusive right, for that quiet, peaceful, and enjoyment. The landlord has to conduct himself in a lawful manner when he enters the property. And if the tenant breaches the lease, you still have the right to live in that property. Your right to live there does not extinguish until or if you either terminate your lease and voluntarily leave, or if you are evicted and the court orders you to leave, at which point your right has ended. If the tenant breaches the lease, landlord can evict, but he still has to follow all those laws. They cannot change the locks. They cannot physically remove you from the property. That is against the law. So here are some examples of the things the landlord cannot do in order to force you to move. They can't do self-help. They can't change the locks themselves and kick you out and throw you out on the street. They have to follow the legal process, which includes giving you notice, filing the case in court, going to the court, having the hearing, having a magistrate or judge determine that indeed you must be evicted, and then having a set out date. At the end of that process, that is how you are removed, not by the landlord. The landlord cannot continue to enter your home to harass you. They can't remove your property without that eviction action, and they can't evict you for reporting them for health or building violations. You are entitled to make those complaints. Sometimes we will hear landlords say, I didn't know they lived there. We thought they abandoned the property. So what does it mean to abandon the property? If it's abandoned, then the landlord may not actually be required to go to court. However, it's risky for them to rely on abandonment because you could just be going on vacation, right? It's hard for landlords to prove abandonment because they have to show that you unequivocally relinquished your right to the property. The fact that you're not there is not good enough on its own. The eviction action protects the landlord because that way they're not trespassing if you're just on vacation and they assume that you've moved out. As far as what your obligations are, you also have to keep the unit clean, safe, and sanitary, but so does the landlord, right? Because they have those obligations to make those reasonable repairs. They have to clean and properly use electrical and plumbing fixture, comply with all the laws, and make sure that those appliances that they provided are in good working order if required by their written rental agreement. They cannot disturb the quiet enjoyment of other tenants, and they have to have reasonable entry, right? And so how do we actually enforce the landlord's duties to do these repairs, John?
Yeah, so this is a problem we run into a lot. A lot of callers will say, my landlord won't fix things, and how do I get that done? So one of the common misconceptions, sometimes it happens, is that people think, well, I'm just not going to pay my rent until they fix, whatever it is that needs taken care of. And you can't do that in Ohio. That can get you evicted. And so that is what we call rent withholding without court escrow. So Ohio has a provision that you can actually deposit your rent with the local municipal court, and they call that putting rent in escrow to force your landlord to do repairs. So when repairs are needed, you should document those, get them in writing, take pictures, do what you need to do to be able to sort of prove that they were there. You can also call your health department or building code to do an inspection and make a documentation of what is needed. And if you're on Section 8, then you can call your local housing authority and they can do an inspection. Give a written list to your landlord. As a general rule, only repairs involving material health and safety will justify a rent escrow. And so again, kind of you judge that based on, how close it is to, a health and safety violation. So if your sink is not working, you don't have running water, that certainly can be health and safety. If, the wallpaper is starting to come off the wall a little bit, that may not be a situation that would affect materially your health and safety. And so you would not want to escrow rent in that condition. It doesn't mean you can't tell the landlord about it, and hopefully the landlord will make the repairs, but rent escrow would not necessarily. apply. So the more severe condition, the sooner repairs must be completed. Sorry about the light in the background, but it's a nice sunny wintry day. But if if the windows behind me were broke and they were the cold air was coming in, that would be something that the landlord would have to. We would call that probably a severe condition because of being how cold it is, and the court would view that as needing to be taken care of soon. So general rule is 30 days that a landlord has to complete repairs, but again, more emergent things will require them to be done sooner. So what is this rent escrow procedure at the court? So it generally does not apply if the landlord owns 3 or fewer units, but it certainly can, depending on the nature of what is going on with the repairs that are needed. But you can go to the clerk of court that handles eviction in your area, file an application to escrow your rent. They may take out a filing fee. Very important to note that to do this, you can't just do this sort of overnight. You do need to give your landlord written notice first, give them an opportunity to make the repairs, and then if they don't, then you can do that. And you have to go there before the rent is due, or no later than the due date. And so I can't not pay my rent in February and then go say February 10th and try to escrow the rent for February. I would need to go today or up until the 1st. So the rent escrow statute allows you a couple of options. So if your landlord is just not making the repairs, you can ask to terminate the rental agreement and move. If your rental agreement says you still are on the hook for 6 more months of the lease, you can get the court to agree that that is terminated and you no longer have that obligation. But you can also request that the landlord do the repairs and have the money released to have the repairs completed and to reduce the rent until the repairs are done. And I can do the security deposit if you like, Igor, since he's been doing a lot of talking while I still have some good voice left. So this is kind of what to do about that security deposit and how to make sure that you can get it if when you move afterwards. So first thing, get a receipt. So we see that a lot where people say, I paid a security deposit, but they don't have a receipt. Often it's good, it's in the lease, and sometimes the lease will acknowledge that you did pay it, and that generally is good enough. Important to do a move-in inspection and take some documents. Today with cell phones and video capabilities, it's good to do that. You may assume, when you move in and you see that, the cabinet is broke, and the landlord says, well, it's not something that is really that pertinent. It's in the other room. We don't care about it. You don't care about it. And then when you move out, all of a sudden it's like, hey, that cabinet, you broke it. And so you want to make sure to have documentation of that. Also important that you give proper notice before you move out. Typically in your written lease, there'll be a requirement in there about how much notice you have to give and how you give that notice. And so if you don't do that, you may forfeit your security deposit. So when you're getting ready to move out, you want to try to leave the place in the condition that it was similar to what it was when you moved in. And you're not responsible for normal wear and tear. And what does that generally mean? Like painting, it's assumed that if you've lived in a place for a number of years, that the paint's not going to look as fresh as it did the day you moved in. Does that mean you need to repaint the whole unit? No. Carpet cleaning, again, that's sort of normal wear and tear. But if there are things beyond that, then you may be responsible. So schedule a move out inspection with the landlord, have a witness present, or if that's not really feasible, document with photographs or a video. So important, Ohio law makes a distinction about when you move, and that distinction sometimes relates to the return of the key. And so if you don't return the key, Ohio law may view that you are still in possession even though you've moved out. And so some people leave the key on the counter, those type of things. You can do that, but make sure that you have something in writing from the landlord, maybe even a text saying, okay, I acknowledge you left the key there. But it's better to go and hand deliver it to your landlord and get a signed and dated receipt that you returned the keys, and have a witness doing that. So you do have to give your landlord a forwarding address if you want to get that security deposit back. Some people say, well, I don't want my old landlord knowing where I live. They don't necessarily have to know where you live, but if you have a security deposit that you want sent back, you have to give them an address that they can send it to. And if they don't do that, if they don't send it to you within a timely fashion, this is 30 days, then they can be liable actually for double the amount that they withheld. Certainly landlords can take out deductions from the deposit for repairs or rent that wasn't paid, but they do have to document that. So if your deposit is not returned and you think that you are owed it, you can, as I mentioned, get twice the amount wrongfully withheld, and you may be able to get attorney fees. And so we do get people who call us about that. Sometimes we'll do those cases, but often we can refer those to other attorneys who will do them because they know they can get paid for that. So I'll turn it over to Igor to kind of run through. We've got some slides here about if you're in subsidized housing, and so we're going to just kind of skip through those a little bit just to see, what that relates to. So Igor, take it away.
So without getting into too many details and getting bogged down in the weeds, if you live in subsidized housing, the important thing to remember is that there just may be additional rules. For example, a separate notice from the notice to vacate, commonly known as the 3-day. Sometimes they have to actually specify the grounds for the termination. You may be entitled to a hearing before actually going to eviction court. So that hearing would actually be with your housing provider. You may have a right to administrative hearing, to meetings before a third party. You may have a formal hearing, an informal hearing. You may have the right to meet your landlord before an eviction is filed. So there are all sorts of additional protections that exist if you live in subsidized housing. So the main takeaway of that is if you live in subsidized housing and you're at risk of losing your housing, you may want to reach out to legal aid or an attorney to advise you of your rights to make sure that your rights are being protected and that you are getting your due process, that you're following the procedure, that the housing authority, that the landlord are following that procedure. And you want to do that as soon as you believe something is wrong. If you receive a notice saying, we're proposing termination or something along those lines, because there are timelines and deadlines that you have to meet. Otherwise, you may not be entitled to those additional protections, like those hearings, if you never request one. So Ohio has its own rules about the termination notices, and that's codified in 5321-11, which is the notice of termination. You can get a 30-day notice to tenant if there's a material or health and safety violation, and it has to specify what the violation is. So for example, if that violation is there's garbage that you've left all out, then you know how to fix it because you have that right to cure that violation. Separately, 1923-04, this is really about evictions. It's the notice to vacate. It has to be properly served by a landlord before an eviction is filed in court, and it has to give you a minimum of 3 days to move. Commonly, we see these for non-payment of rent, late payment of rent, or non-payment of other charges. For example, if you have fallen behind and you haven't paid, or any really charges except for security deposits that you may be on the hook for. Non-monetary reasons that we see evictions are allowing your conditions to become unsanitary, disturbing neighbors, criminal behavior, which includes your guests and visitors who are there with your permission, or if you've committed property damage. In subsidized housing, there are additional obligations that you undertake because of the nature of the housing. For example, you cannot have an unauthorized occupant. You cannot commit certain criminal behavior. Failure to report your income or changes in income, failure to meet the program requirements. This is usually found in the administrative plan for your housing authority, and it's going to be a document that you sign several times when you move in. And so make sure you hold on to that so you know what you're agreeing to. It doesn't mean you can't have visitors. It doesn't mean that you can't have a friend come and stay the night occasionally, right? But it means there are obligations that you undertake and certain procedures that you have to follow if you want those things to happen. So review your lease and review those additional provisions to make sure that you are in compliance. John, do you want to talk about the eviction process itself?
Sure. So we can run through this briefly. So if, as Igor said, landlords are not allowed to just remove you from your property if they think you haven't paid or there's some other reason. They do have to file in court. What happens is that of course will be a complaint, maybe on your credit report. So what you'll often see is a first cause of action, and that's whether or not the landlord is entitled to have you removed. And typically that court will set a hearing fairly quickly. And if you lose, you may only have a relatively short period of time to move. Igor mentioned in the beginning that it could be as soon as one day or the next day. We've seen that happen. Sometimes courts give more time than that, especially during the pandemic. It's encouraged that they do that to allow people to safely move. But there's no guarantee in Ohio law that that has to happen. So I mentioned first cause. First cause is to have you removed. Sometimes landlord will put in there a second cause in an eviction, and that's the claim for money. What you need to know about that is that if you dispute what the landlord is saying and you want to preserve your right to defend on what he or she says that you owe, you have to file a written answer. And if you have any claims against the landlord, you would need to file those claims at that time. We do have, again, those forms on our webpage. As I mentioned earlier, that's www.communitylegalaid.org. You can go to our eviction toolkit. So basically, the step-by-step is that Igor mentioned the lease termination notice. There may then be a 3-day notice. You don't necessarily need both of those depending on the situation. But if you did not pay rent timely, then a 3-day notice would generally all that is required. But there are other things then you would go through that process. So we touched on, I don't know if we can kind of skip through, I think the Section 8, we talked about that as a possibility. The big thing to know about that is contact your local housing authority if you want information about Section 8 and see if you're eligible. I can run through manufactured homes briefly here too. So we talked about that in the beginning, sort of the difference. Sometimes, again, these referred to as mobile homes. There is a difference between whether or not you own the mobile home or you're renting that. And you have certain additional protections if you actually own the home and that you're renting the lot. So if you do own it, the operator of the park must offer you a written lease of no less than 1 year and must offer the obligation or the opportunity to extend that. They must offer you notice of the rules, and so that you cannot be evicted or forced to leave for some unreasonable, arbitrary, or capricious condition that they made up. It's got to be in writing, and you need to be notified of those things. So the park operator, if they have that rental term, as I mentioned, has to be at least 1 year. They can't increase the rent obligation during that term of that. And when that term expires, they can offer you a new term for a new amount. They can't necessarily require you to purchase services from them, and they can't engage in intimidation tactics saying that, they're going to turn off your access to electric. Their obligation is very similar to what Igor talked about under the Ohio landlord-tenant law. You, as a park resident, again in mobile home, you have the same obligations that Igor talked about. But sometimes we run into this, that the operator of the park intends to sell the park. Then you actually have 4 months or 120 days to vacate. If you are an owner of the mobile home, you have 180 days. So you can look into that, and again, call us if you're running into those situations. So there are a number of reasons that you can be evicted from a mobile home, and those are very similar to what Igor went through on the prior slide. So you can run through maybe just these are just some things to be aware of if you're in these types of properties.
Yeah. So if there's criminal activities involving you and you live in subsidized housing, it may actually jeopardize your ability to live there. And sometimes there are lifetime bans on living in subsidized housing based on what your criminal activities are or have been. For example, if you manufactured or produced meth on housing authority property, then you will be permanently denied public housing. If you are permanently on the sex offender registry, subject to a lifetime registry, then you will receive a permanent denial. And for Section 8, there are additional provisions, including drug or alcohol abuse, as well as all of these things affect your ability to sometimes even be admitted into the program itself. Other housings, they have their own rules. And there was a case called Rucker that talks about those criminal activity evictions, and talks about who is reliable or who is liable under the law for those criminal activities, which once again does include your guest. So that's one of the things to watch out for. And you do not require a conviction, because in a civil case, they just have to show that it's more likely than not that a criminal act occurred. They don't have to show it beyond a reasonable doubt. And so that is very important distinction, and one that we see a lot of confusion on. And so you would definitely want to inform your criminal attorney if you're facing criminal charges about the fact that you're in subsidized housing. So that way they may be aware of that, because being convicted or pleading down to certain offenses may make you ineligible to remain in your housing. So that's something to definitely look out for. Fair housing prohibits discrimination based on race, color, religion, national origin, disability, marital status, familial status, or gender. In Medina, that also includes sexual orientation, with the city council passing additional protections. So the federal law provides a bare minimum. All of these categories have to be protected, but local cities and counties, they can actually expand those to include others, including, for example, veterans. And so an eviction, if it involves somebody with a mental disability, the fact that you have that disability may actually be a defense if the conduct is related to your disability. You can, under the law, request a reasonable accommodation, which is based either on the Fair Housing Act or the Americans with Disabilities Act. And what this allows is for you to actually potentially remain in your home, or to get some sort of accommodation that will allow you to remain there. For example, if you were screaming or something like that happened because one of the side effects of your medication is paranoia or restlessness or sleepwalking, right? Then a reasonable accommodation may be appropriate. The example that we have is a disabled tenant who created serious unsanitary conditions is given an opportunity to obtain regular cleaning services in order to avoid eviction. So, for example, housekeeping or to have somebody come out. Lead paint is a huge issue in Ohio, and the landlord actually has a duty to repair lead exposure that they know of. They have to give you a lead disclosure saying that whether they know of any lead in the home or whether they do not. This is something that we see commonly, unfortunately, with children, and it has lifelong effects for their life. And lead is in over 80% of homes built before 1978. There are many, many of those homes in Northeast Ohio, and a large amount of low-income people, which are our clients, tend to live in those homes. So it does not have to be just paint chips. It can be deteriorated paint, it can be dust, it can be soil that's contaminated. And so lead is something that's very, very serious. And you should, if you are interested, you can test your children in order to determine if they've been exposed to lead. You can do that by contacting your local health department or your school or your doctor. And we have some information here on lead that you can look up by going on the epa.gov/lead website. And all of this, you can pause the video at any time because I know we're going kind of quick, so you can always get at these resources afterwards, including the National Lead Information Clearinghouse information. So how do you contact us? You can call us at that phone number, which is our hotline. You can go to our website, communitylegalaid.org. You can check us out on Facebook, on Twitter. I think we even have an Instagram. And that is the end of our presentation. I'm looking here in the chat and I don't see any questions, but we're happy to take any questions. And I do notice that the Medina County Board of DD, who's graciously hosting us, has said that today's presentation will be available on their website under the resources tab, so you can come back anytime. If there are certain things in this presentation that you are interested in reviewing. And once again, if you have a specific question, the best way to get that question answered would be to apply for our services. And if you're deemed eligible, we're more than happy to give you that individualized answer.
And as Igor mentioned too, during the pandemic, we've been doing eviction clinics virtually every Tuesday at 4 p.m. And so if you are facing an eviction and you want some information, you can certainly call us, but you can also go to our live eviction clinic info on our website. If you go to communitylegalaid.org and look on our events page, you'll see the link to that. And so we hope you found the presentation helpful. This is kind of a general overview of what your rights as a tenant are and some of the obligations that you may have. And we appreciate Medina County for asking us to come in and provide information to the community.
John and Igor, I just want to say thank you for your presentation today. Again, I don't see any questions coming through, but they have your information, so they can definitely reach out to you with any personal questions they may have.
Okay, great. Thanks, Tiffany.
Thank you, Tiffany.
Thank you, everybody, and have a wonderful day and a wonderful weekend.